And so, John, I was thinking that during the we could sort of like stage in and out. So during the panel section, you could have your camera off, and we could have Ifeoma, me, and Veena on, and then during your section, we can turn our cameras off, just so that people are focused. I don't know if it is zooms in on the speaker or not. I'm not sure how it's set up, but I can't hear you.
I missed part of that, but you're saying turn my camera off until it gets to my section.
Yeah, and then we'll turn ours off, unless
Sure.
Kyle or whoever this is sort of configured to zoom in on the speaker, but just from an attention perspective, that seems the most.
Sure.
Well, we're live now on YouTube. I can see us. And it does, so like whoever's talking, it's like the Zoom thing. So whoever's talking just like takes the entire screen, just FYI.
Oh, cool. Well, on YouTube, hi, this is the sausage making YouTube.
It does have that like 15-second delay. So they'll hear that in a couple of moments.
Cool.
I'll use the panelists. You can see this, everyone, in the chat. I just typed we're live now on YouTube.
Great.
So I'll use for timing. So I'll give you when we're halfway through your time based on the run of show. And then when you're like, I don't know, like 30 seconds from up, and when you're up.
Cool, thank you for that.
Okay, I can't see the chat because I'm just on the voice.
Sense.
So
can I text in the thread, Veena? Will you be able to see that?
Yeah, yes, that would be perfect. Thank you. And I don't anticipate going over by any stretch of the imagination. I'm sort of exhausted from talking today. But I will look out for the chat.
Great. And we're not we're gonna go minimalist. And thank you so much for being here, Veena. And I think we're just waiting on.
I'm so excited. I'm really excited. I mean, this is something that we've sort of fantasized about, like in drivers meetings. Like, what if we could just get someone to like tell us?
I know.
So it's so great.
Like, come forth. Thank you, Kyle. Great. So are we live? Great. Thank you all. Thank you all for joining us. We're really delighted to be co-hosting this event. This is dedicated specifically to tech workers, and we're going to be discussing the importance of whistleblowing in tech from a number of different angles. And John, who joins us today, is going to be giving us a kind of brass tacks tutorial on how tech workers can blow the whistle as safely as possible. So before anything, I want to thank Kyle at Whistleblower Aid and Alejandro at the AI Now Institute, who have done tremendous work to prepare for this event, setting up the infrastructure, helping field questions, just doing a huge amount of labor behind the scenes. And we're really grateful for that. Thank you both. I also want to give a quick caveat. We're speaking from the United States right now, and we're going to be talking about a US legal context. So much of the nuts and bolts in the how-to section won't apply to other regimes, although the broader discussion on the imperatives of whistleblowing knows no borders, and this is a discussion that we want to extend beyond the US context because, of course, the importance extends well beyond. So to start, I'm going to give some lightning fast thoughts on why whistleblowing and those who engage in it are so important in tech in particular. Then I'm going to have the deep privilege of moderating a discussion with two incredible people whose thinking has done a lot to shape my own, Ifeoma Ozoma and Veena Dubal, who will offer their knowledge and perspective on this topic. And then after that, we're going to welcome John Tai, the co-founder of Whistleblower Aid and a whistleblower, who will be giving us, again, the tutorial on the basics of whistleblowing, particular in tech in the US. Throughout, we're going to open it up for your questions. So a link to Slido, which is something I don't quite understand, but I'm assured that it's in the YouTube discussion. And the event number is F554. Hashtag F554. So you can submit questions there and they'll get to us at the end. We'll be doing Q&A. There's also a signal number that I believe is also in the YouTube description. So you can submit questions to us throughout on those platforms, and then we'll be answering those we select at the end. So if you're here, you probably already know that the tech industry has massive and in some cases unchecked power. And this is a growing concern, across disciplines, across perspective, across borders. Its media platforms are shaping what we see and how we understand the world. Its AI capabilities are threading through our core social institutions, informing socially significant decisions in ways that are often completely hidden from the people whose lives they're shaping. Tech surveillance and tracking infrastructures are feeding everything from its targeting algorithms to systems of massively scaled worker control and extraction to government targeting of Black Lives Matter movement leaders. And that's just what we know. Indeed, much of what we know, much of what I'm referencing is thanks to whistleblowers. And I think this is a fact we don't appreciate enough in the broader tech accountability discourse. I'm going to just run through a handful of examples of big tech accountability moments, as I'll call them, that we know only thanks to whistleblowers. We only know about Andy Rubin's $90 million sexual harassment payout following multiple credible claims of sexual assault and harassment at Google, thanks to whistleblowers. And this catalyzed part of a growing tech worker movement. We only know public information about Facebook's lax rules and coddling of authoritarian content creators or posters due to whistleblowers within the company. Much of the information we know about Amazon's warehouse conditions are thanks to organized workers blowing the whistle. Indeed, today we just got new documents showing that indeed these workplaces are so inhumane that people aren't able to relieve themselves in the dignified and proper way. Same with Uber's broken promises and exploitation. Google's role in Maven, we know thanks to whistleblowers. This was the Pentagon project that was building AI infrastructures for drone targeting for the US's role in the drone war. Google's Dragonfly program, this was the censored version of its search engine dedicated to a Chinese market that was shut down only after whistleblowing and protests. Pinterest's virulent racism and sexism, only thanks to Ifeoma here and her colleague Erica Banks. And the list goes on, right? So many of the crises we know in tech, we know due to whistleblowers. Meanwhile, the cultures within these organizations are famously toxic, with racism, misogyny, and ableism consistent and near unchecked problems. and a handful of mainly white, mainly men reaping in absurd profits while hundreds of thousands of workers see none of these gains. It's no accident that those who often speak up about these unethical and harmful business decisions are the same people who face marginalization and harm within these corporate environments. I'm thinking right now about my friend and comrade Timnit Gebru and Margaret Mitchell, who were retaliated against by Google. And I'm thinking about so many others who refuse to be silent even under these pressures. So it's clear that whistleblowing is vital to robust tech accountability. And it's a significant mechanism by which we are able to understand, to map, and ultimately to resist these oblique and expansive corporate infrastructures. As researchers, organizers, and advocates, we owe a debt of thanks to the brave people who we may or may not know, but who nonetheless took significant risks to disclose harm within and outside of tech in service of the public. So with that brief preamble, I'd now like to ask my friends and distinguished panelists, Ifeoma Ozoma and Veena Dubal, who's going to be joining us on audio today, to introduce themselves and give just a bit of background about their work and the experiences and intellectual engagements that brought them here. So Ifeoma, I'll start with you, and thank you so much for joining us.
Thank you so much. I'm so excited to be in conversation with you and Veena and John, and thanks so much to Kyle and Ale for helping with everything behind the scenes. My journey in tech started actually when I was in college still, at Yale. And I interned at Google in DC. At the time when I got the internship, I didn't even understand what Google was doing in public policy and why Google had an office in DC and why there were so many people working there. And from there, I went to Facebook. My experience at Facebook, I seem to start at these places at moments where there's nothing but drama. I started right before Trump was elected. And I remember one of the first all hands being around Mark saying that Facebook had no role in the election, and there was no chance that Facebook had a role in the election. They seem to have not learned from that, because Cheryl repeated almost the exact same sort of line about January 6th and Facebook not playing a role in the insurrection. And from there moved to Pinterest. And my experience at Pinterest, the work itself wasn't so different from the work I was doing before, but my experience there was different in that I came in thinking that my eyes were wide open after working at Google and at Facebook and seeing how terrible things could be, and just not understanding the extent to it until I raised my own wage discrimination concerns, raised them the way that all tech employees are told you should raise things. First with your manager. I did it in a respectful manner. I did it in writing. That was my first mistake, according to him and the company, but actually the first thing that I did right, because by raising it in writing, even though I raised his ire along with the complaints, I was able to create a history and a track record that ended up being useful for the legal counsel that I had to hire. I was eventually pushed out of Pinterest. There's lots to be read about it, and decided to go public with my own concerns. One of the reasons why I'm working on tech accountability and whistleblowing now is to put a focus really on taking away the barriers that exist for people in speaking up. As much privilege as I have in my education and the jobs that I had, I'm still a Black woman. I'm a Black woman who was pushed out of a job at the beginning of the pandemic. We just passed the 1 year mark of when I was forced to leave and to sign an NDA. And I say forced to sign the NDA because the only option I had was to not have any compensation, which would have meant struggling with rent, struggling with paying for basic bills, and no health insurance at the beginning of a pandemic, and a pandemic that I understood was going to be as serious as it was, because just the month before I was in DC at the National Academies of Sciences presenting on my work on health misinformation. So one of the things that I'm focused on now, outside of the whistleblowing work that I'm leading and putting together resources for tech employees and tech workers, who have no idea what the process is like, is also removing the barriers legislatively, because I think we need both the outside approach and the inside approach when it comes to policy work. And I'm leading work on getting the Silence No More Act passed in California, which would formally remove any sort of barrier that people who sign non-disclosure or non-disparagement agreements have in sharing discrimination or harassment that they face in the workplace or in housing. And that's something that's really important for California and for other places to be aware of, that people who are in positions where their labor can be coerced or their agreement can be coerced are often in situations where they're faced with discrimination and harassment. And whether that's housing and a landlord you're dealing with who's being abusive, or in the workplace and an employer, it's important that no one is silenced for the rest of their lives just because they don't have any leverage.
Thank you so much for that overview, Ifeoma, and for again, for your bravery in bringing this to light. I'll turn now to Veena. And Veena, I would love if you could just introduce yourself, and particularly if you could speak about the harms of tech opacity, of the secrecy, especially to workers who are subject to these systems of technological control and worker control. What kinds of information should those in corporate jobs be thinking about contributing through whistleblowing that would aid in these worker struggles?
Yes. So first, I just want to say I'm sorry. I'm with you only by audio. I outside of Walgreens just got my vaccination, and I want to say thank you to Meredith and Ifeoma and everyone, John, Ale, Kyle, who has put so much effort into this amazing event, and really thank Ifeoma and all of the whistleblowers who might be listening, who have put their own lives and livelihoods on the line for the greater good. And I have deep admiration for you, Ifeoma, and it's just an honor to speak alongside you. So when I think of whistleblowing, I really think of it through the lens of tech ethics and resistance and solidarity. So not everything, of course, that a whistleblower might whistleblow about is fundamentally illegal, although I think John will tell you that that is maybe illegality is more fungible than I imagined. But much of what people have blown the whistle about in tech violates sort of ethical norms and suppositions about what it means to create a moral world. And in my work, I find in particular a moral world of work. So as Meredith alluded to, I am a law professor. I study the so-called gig economy. In particular, I study and organize alongside ride-hail drivers in California who are working to get a just basic protection so that they can lead semi-secure lives. So in my research, what I have found is that we went from this moment in 2012, 2013, where everyone just sort of embraced the grift of these gig services as being pro-social and promising collaborative consumption and being really efficient and matching, the closest rider to the closest driver. We went from this sort of utopian vision of what these companies did to really understanding them as very exploitative systems that are sort of, creating more and more exploitative systems in our economy. And the only way that we found this out was really through whistleblowers and through drivers. And the important things that the whistleblowers did was that they really gave credence and validated all of the things that drivers were telling me in my research, that they were telling journalists, but that people just really weren't paying attention to. So in effect, these sort of Uber gig economy whistleblowers have shaped how drivers understand their work, and their sort of lifts the veil on the black box algorithms and opaque tech controls that squeezes, every ounce of blood and sweat out of these low-wage, subordinated racial minority workers. So, just two examples that I can offer you, and then I would love to answer Meredith's question and offer some of, share some of the things that workers want to know. Operation Grayball, we knew that Uber was engaging in all kinds of regulatory arbitrage, but really I think Operation Grayball, which was, revealed by a whistleblower, underscored for regulators that they were really being had over. So that, of course, is the tool that Uber used to collect data from the app to identify and circumvent officials who were trying to regulate the ride-hailing service. And it was also whistleblowers who unveiled that Uber was engaging in this extraordinary behind-the-scenes experiment in behavioral science to manipulate workers in the service of corporate growth. And this was the most validating piece of information that drivers could have, because there is a sense in which they notice patterns about the ways in which they are being taught to behave in certain ways, to do certain things by their app, by their boss, but it's always just a hunch. And so this was an extraordinary, validated, and an important insight, both for the workers themselves in their everyday lives, but importantly, I think it's important to remember that in this work, to prove that workers deserve basic protections like minimum wage and overtime and unemployment insurance and workers' comp if they're injured on the job, workers themselves need to prove that the employer, that the companies control them in the workplace. And so in Uber's case, and really with all of these gig companies, they exert these controls through algorithmic manipulation, and that's what was unveiled when we found out about this behind-the-scenes social science experiment that was happening over at Uber. But what workers really want to know is exactly the ways in which this is happening. So for insiders inside these companies, thinking about how they can support the organizing of drivers, or even support some of the litigation and regulation of these companies with regard to their labor arbitrage and labor exploitation, really understanding how and what mechanisms the companies use to control workers, like the specificity of the mechanisms, is so vitally important, particularly in litigation, to make visible the control that the companies work so hard to make invisible. It's also, I think, really would be very useful to understand, and this is a huge black box for us right now, really useful to understand how the companies use the driver's data to create new products, not just for them, but for perhaps products that they can then sell. This is something that, drivers in Europe are really fighting to get information around, and also are starting to do the same in the US. But it is a huge source of anxiety for workers to not understand sort of the predatory practices that control and exploit them in their everyday lives. And these forms of information that I think sometimes engineers and creators think of as being, interesting products that they're working on, would actually be quite useful if they were understood in the larger political economy of the work that's being conducted. And so sharing that kind of information, whistleblowing in those ways, it would be, an incredible, offer incredible insight, really support the organizing of low-income workers, and do a lot to regulate the labor arbitrage in the economy that I study.
Thank you so much, Veena, and we'll come back to this question about kind of continue a discussion of the wish list for whistleblowing and solidarity, because I think that it's really important. But now I want to turn to Ifeoma, and Ifeoma, I want to ask a little bit more about your experience at Pinterest. When did you decide to blow the whistle, or how? And kinds of information do you wish, information and support and solidarity, do you wish you had then that you would suggest to kind of share with folks who are thinking about whistleblowing now?
Yeah. Well, I started in July, and I sigh because I've told the stories so many times, but in this context, I'm excited to tell it again. I started in July of 2018, and it was in September of that year that I realized that I was being paid at 3 levels below what I should have been, which was a fun revelation when you're a few months into a new job. I was doing work already at that point that was very public. And so I thought, they can respond in many ways, but I'm going to try to come at this with as much documentation as I have. Like, here's the level chart. Here's a description of the work that I'm doing. Here's a description of the work I was told I would be doing. Of course, it went poorly, and I started facing retaliation right away. I still didn't even think about whistleblowing at that point, even though I knew that there had to have been other people who were experiencing the same thing, until I was doxxed by a white supremacist colleague who was working with Project Veritas. So, and he works there now full time, which is fun. But when I was doxxed, it wasn't even the doxing that made me certain that at some point I would tell my story. It was the company's lack of reaction, because the same people, the general counsel of the company, Christine Flores, Ben Silverman, the CEO, and others who were aware of my wage discrimination complaint, then stepped completely back and left me to the white supremacists who now had my cell phone number, my photo, everything. And I discussed it with my lawyer and said to him, like, I knew that they didn't care about me, but I didn't think it would get to the point where they were fine with people who are sending me rape and death threats to just have at it. And I still didn't leave at that point. That happened in the summer of 2019. And I didn't leave until May of 2020, because I thought, you know, I'm going to give them as many opportunities as possible. I filed a complaint with the state. I had a lawyer through most of the experience. And the one thing that I actually felt like I was very prepared through this because of colleagues that I had at Google and at Facebook who had experienced the same thing and told me from the beginning, you need documentation for everything. So I made sure that when I first raised the concern, I raised it over email. And of course, I had many one-on-one conversations with my manager that were incredibly uncomfortable, with HR as well, with the general counsel, with others. But all along the way, I documented everything such that when I reached out to my attorney, I had, here's the history of things that has happened. Here's all of the work that I've done. Here's the internal documentation. And he actually said to me at that time that he thought it would be 10 hours of work, if even, for him. I had him on for over 10 months, I think, and still go to him for advice. So when I finally did decide to go public in June of last year, I did it knowing that the company could sue me. And one thing that I think that's important to understand is companies can bankrupt you without actually winning a lawsuit. I spent, and this is a privilege again that I had, and I'm completely transparent about this because I do think it's important to use the numbers so that people have a sense of how much this can cost. I spent $40,000 on legal fees, $40,000 that I could only spend because I thankfully don't have student loans, because I don't have a child I'm supporting. I don't have a spouse or a parent I'm supporting. And I still had to sign the NDA that I was forced, that was put in front of me, even though my lawyer explained, like, these terms are not great. Like, this is not a great deal, but this is the best we're going to do, because I still have to support myself. My sister lost her job a few weeks after I signed it. And I'm so thankful that I did, because I was able to help her when she no longer had a job at the beginning of the pandemic. So, I mean, I feel like I was as prepared as one can be when I decided to go public. I'd worked with a lot of reporters as part of my job, so I knew which ones to avoid because not every reporter is the same, not every outlet is the same. And I knew the ones who had a long record of covering issues that are germane to women of color and to labor in a responsible manner, because there are others who didn't, and some who are willing to play the corporate access game and allowed Pinterest to provide defamatory, in my opinion, statements about me and my colleague Erica without attributing a name to it, even though as the whistleblowers, we had to have our names and our faces on everything.
Well, thank you for sharing that with us and for your unflinching candor in telling such a frankly fucked up story, and for now doing the work on behalf of others who might experience these unjust situations. So yeah, thank you for that. Veena, I'm gonna turn to you now, and I would just love again to get your thoughts on how you see whistleblowing, particularly kind of whistleblowing from these kind of corporate tech environments, fitting into larger strategies for accountability and specifically worker organizing and the worker movements that have been led by app-based precarity workers at Uber and Lyft, drivers, et cetera, and have been joined as well by white-collar tech workers. And now we see, what to me is a very hopeful movement on the swell.
Yeah, I want to start just by sharing a short story. My first Tech Worker Coalition meeting, and for those of you who don't know, Tech Workers Coalition is sort of a loose group of workers in tech all over the country that are sort of thinking about organizing in their workplace and organizing around issues of tech ethics, as well as workplace conditions, and seeing the intersections between both of those things. So that was my first meeting, and we were doing introductions, and I sat down and I talked next to the guy next to me was a gentleman who worked at Square, and he articulated this completely sort of fascinating revelation that he had in the weeks before. And he said, he had started to think about how the things that he did at work actually impacted the everyday lives and behaviors and conditions of the immigrant workers who were sort of downstream. And he said this particularly, he had this moment where this was an Asian American worker where he saw, I think it was a food delivery driver or some sort of gig worker who was similar ethnic descent, and really just like visualized a family member who was on the precarious situation on the margins of the economy, and thought, wow, like what I'm doing, the things that I'm creating actually have this sort of downstream effect. And it's why he sort of got involved in tech worker organizing. And I say that because I don't think it is completely obvious to everyone that a huge part of the tech-fueled service economy is actually just finding new ways to control and manipulate workers as they do their jobs. So it's no longer just like scientific Taylorism that shapes, how workers move or behave at work. It's now sort of what I call algorithmic Taylorism, in the sense that because if you exert a lot of actual control in the workplace, or no, I shouldn't say actual, if you obvious control in the workplace, a court will find you liable for all of these various things. Companies are finding it a lot of legal freedom in pretending not to control people and otherwise controlling them, or alternatively, just in places where the companies are clearly the employer, like an Amazon warehouse, is just being ruthless in the amount of algorithmic in the types of algorithmic Taylorism that they engage on the job. And in both of these contexts, what's so hard is that we just really don't know how these things work. Everything that we know, as Meredith highlighted at the beginning of this talk, everything that we know is really from what low-income workers tell us. And to have inside corroboration, and not just inside corroboration, but really details of the types of things that are being produced internally, the types of products that are being produced to control workers on the job. This, again, could have a huge impact on litigation, on regulation, and on resistance. And so, you know, there is a very clear and obvious organizing pipeline between white-collar tech workers or workers who might imagine themselves to be white-collar internally at these places, and the folks who are at the very, very bottom of the assembly line, so to speak, who are getting paid the less and doing the most sort of ruthlessly exploitative work. And if you can make that connection, if you can think about the work that you're doing in the broader context of the political economy that's being produced through your labor, then you think about yourself as someone who can through whistleblowing, through sharing information, through organizing, as someone who can have an impact in those ways, then you truly can have a huge impact. Every tiny bit of information helps us piece together what is going on behind what is otherwise a black box. And it is what's happening in that black box that is critical, I think, to fundamentally reshaping the possibilities of both resistance and of sort of liberation beyond the black box in the workplace for the most vulnerable among us. And so, you know, for those of you who are listening who are working at some of these places and who have thoughtful sort of insights about the implications of what your employer is doing sort of down the pipe, those are the types of things that I think would be really useful to know about.
Thank you so much for that, Veena. And I'm just going to put a quick interstitial plug in here. You don't have to hypothesize this stuff alone if you're a white-collar tech worker. There are organizations like Tech Workers Coalition, there are Rideshare Drivers United, there's Gig Workers Collective, New York Taxi Workers Alliance, and others where you can talk to workers who are struggling under these algorithmic regimes and begin to co-create strategies for mapping and discovery. So I want to
absolutely. And if anyone wants to get in touch with those organizations or with me, my email address is public. Please feel free to reach out, or, you know, through other channels.
Yeah, no better person to collaborate with on that. Thank you, Veena. And I want to end this panel section quickly, Ifeoma, by just asking if you can share a little bit more about the work you're doing to help enable whistleblowers, to help support whistleblowers. You mentioned the Silence No More Act, which is going to do, you know, a big job in California when it passes, I say. And I also know that you're working on other kind of information and support for whistleblowers. So maybe you can just talk a little bit before we close this section.
Yeah, absolutely. And I hope that there's a way to get the links available so that anyone can access the information. But the whistleblower work I'll address first. Right now I'm working on two projects that are connected but different in important ways. One is meant to reach every single person who's working in the tech industry, and I mean that I mean that as inclusively as possible when I say working. And it would be a guide. I finally came up with a name for it. I've been mulling it over, but the Tech Worker Handbook, which plays on the bullshit employee handbooks you get when you first start employment that are just about, especially when you read them back after being in a situation where you've whistleblown, just about protecting the employer. This will be just about protecting workers. And the handbooks will have 4 parts. The first part will provide advice on how to engage with legal counsel. So, and when I say advice, I mean taking it back to the basics, because I want this to be accessible to anyone, whether you've ever spoken to or know a lawyer or not. And it'll include answers to questions like, how do you even approach an attorney? How do you approach the right kind of employment lawyer? Because not every employment lawyer is going to be equipped to work with whistleblowers. What are some examples of organizations that you can work with? The next section will cover media and engaging with reporters, because one thing that is so important to understand, and many people don't if they don't have media training, is that a reporter has a job. You are a source. And so whether or not it is in your best interest, a story can be reported once you share the information. And so it's really important for people, particularly those who aren't signing up to be public figures, to understand that that is always a possibility, whether or not you think you're going into the conversation anonymously or not. And very few newsrooms can actually guarantee anonymity, no matter who you are. So you really just need to be prepared to protect yourself and your family. The next section will follow that and cover information and physical security. So how do you think about the device that you're using that your company probably owns if you're still at the company? How do you think also about the possibility that your company sends a private investigator after you, after your family? It's someone's digging through trash and you had no idea and you weren't prepared for it. It's scary, but I think the more information that we have, the more we're increasing the odds that people are prepared and thus willing to share. And the last section of the handbook will include stories, because I think hearing from those who have whistleblown firsthand is so important. So whether that's through video or writing or audio, I think it's important to collect those stories. And then the second part of the whistleblower work that I'm doing, a little busy, is figuring out a fund that would provide direct monetary relief to those who have lost health insurance as a result of whistleblowing. Your health, it's barbaric that we live in a society where your healthcare is tied to your employment. And yet that is the case. So as long as that's the case, we need to provide a safety net for those who are taking on the burden of trying to change society, that the whole weight of that should not be just on their shoulders, and it shouldn't be on the shoulders of their families either. So how can we provide funds for people who need to pay for COBRA? I'm paying for it now. It's over $900 a month as an individual. For families of 4, that could be $2,200 a month. Until you figure out what's next, you should not have to worry about how you're paying for COBRA, how you're still seeing your therapist, how you're paying for copays for medication. And so I'm taking this year to figure out that and building it and how we get it funded so that people can get access to this. And then for the Silence No More Act, which is entirely separate work, but very connected, that right now is being reviewed by the California Senate Judiciary Committee. If you live in California, I really encourage you to reach out to your senator if they are on the committee. California is a mixed bag. People think, oh, if it's progressive, it should just pass. That's not the way the legislature works. There are a lot of folks who are very business friendly in the legislature. And so we need as many voices reaching out and saying that they support SB 331, which is the Silence No More Act.
Thank you so much for that, Ifeoma, and thank you for your service here. I think, it is scary to blow the whistle because there are power asymmetries, and we have to recognize that, but we are clearly not intellectually outmatched at all. And we are going to have a lot more resources soon, and the good and the brilliant and the righteous people are on our side. So thank you so much, Veena and Ifeoma. You're both luminaries, and I truly appreciate your being here and sharing your wisdom and your stories. So that will close out this discussion kind of framing section. And now, with our deep thanks to our panelists, we'll turn to John Tai, who is the founder of Whistleblower Aid. And he's going to provide us with a brief overview of what whistleblowing is, what it isn't as defined legally, and what the fuzzy boundaries there are, and how to do it as safely as possible. And I want to remind you all that the question link is on, there's a Slido link for questions in the YouTube description, and you can keep submitting those there. We'll have some time at the end after John's tutorial for that. But thank you, John, and welcome, and thank you to our panelists.
Absolutely. Thank you, Meredith, Ifeoma, Veena, Ale, Kyle, and everyone watching. My name is John Tai. I'm a lawyer. I live in Washington, D.C. 4 years ago, I started Whistleblower Aid. We're a C3 nonprofit charity. Over the last 4 years, our lawyers represented the anonymous Ukraine whistleblower whose disclosures led to the first impeachment of President Trump. We handled several other high-profile matters. We've worked with Ronan Farrow on 3 different stories, one about Jeffrey Epstein, one about Harvey Weinstein, and the third implicating Trump's director of the CIA, Gina Haspel. Our client's disclosures blocked at least 2 presidential nominees in the Senate, one for Homeland Security, one for the Inspector General of the CIA, based on evidence of their misconduct. We filed a bunch of cases in the private sector as well, related to financial and technology companies. So I was also a whistleblower myself back in 2014. I worked at the State Department. I had a top secret clearance to receive classified top secret information. I learned sort of after the Edward Snowden disclosures that the NSA was conducting massive surveillance against Americans using a legal loophole. Hired a lawyer, 2 lawyers, paid them $13,000, not as much as Ifeoma, but it was quite significant. Again, very privileged that I knew lawyers, that I had the money to pay them, and then realized this need was there. So that's what we've done. Our model is, obviously I'm a lawyer. We start with direct legal representation. That's the core of the model. So individual whistleblowers, some cases we have multiple clients, but that's far from all we do. We also provide many of the services that Ifeoma mentioned. We've paid people's rent after they've been fired illegally. We've helped them get a therapy and medical treatment and paid for it cash. We are literally providing secure devices that we buy, in cash, set them up, hand them to people, and say, use this to communicate with us. We've paid for armed guards to protect clients. Just today, a man in Michigan was sentenced to prison by a federal court for threatening to murder my law partner, Mark Zaid, for his representation of the Ukraine whistleblower. So we're pretty experienced with this stuff, and we take a very holistic view of the kind of services that we offer to really try to help everyone with all of their problems and make this possible. So happy to be on this panel, and that we have some momentum here in the tech sector. I'll get to some of the cases we've handled in the tech sector already in a little bit. I would say most whistleblower cases have 2 parts. There's the disclosure of wrongdoing by the corporate entity, and then there's the threat of retaliation. Now, these are distinct, but obviously related. The core message I have tonight is come to us as soon as possible, because do not talk to your boss about a problem. Do not talk to your spouse about a problem. Do not talk to your friends. Do not talk to a journalist, because if we can help make a disclosure, we can almost always find a way to minimize or even eliminate retaliation. We can often help keep people anonymous. As Ifeoma said, journalists have an ethical obligation to tell the truth to their readers. They don't have, sometimes they have incentives to publish even when it can harm their sources. Obviously not all journalists do that, but it is a real risk. So our core goal is to help people from the earliest possible stage. So that's the main message. Every case is unique, but typically, I would say, if I had to generalize, there's 3 steps. The first is, obviously, one of the reasons to go to a lawyer first is that we can provide attorney-client privilege. A journalist cannot provide that. That means that it's literally illegal for me to share what you tell me without your permission. I can be disbarred, et cetera. So I cannot be forced to testify against you. So that's a core reason to start with a lawyer first. So step 1 would be finding some reason to take the claim to a law enforcement agency. That could be the Department of Justice, the FBI, a California agency. It could be the Securities and Exchange Commission, the Federal Trade Commission. It could be the European, data protection regulator, or other, European agencies, which often have better rules on the books than the United States does. We've used all of these techniques, and that does 2 things. first of all, in rare cases, it will trigger a criminal or regulatory investigation, enforcement action against the company. But most importantly, it triggers legal protections for the whistleblower. So even if we don't think the SEC is likely to bring an enforcement action, we will very deliberately file, claims, and you can do so anonymously with the SEC, so they know my name as the lawyer, but they wouldn't know your name as the client. And then the minute that thing is in, and we can do it online, it's illegal to fire you. It's illegal to take any kind of action against you. And so even if we think an enforcement action is unlikely, we will very, very often look for either the SEC or some other agency to file a disclosure with to trigger those protections. The other thing about the SEC that most people don't know, it's actually possible to win a lot of money if you are a whistleblower. There are financial incentives. Now, this is quite rare. It's like 1 in 10,000 or 50,000 disclosures generate financial rewards, but those are actually huge. So just a couple months ago, they gave over $100 million to a single whistleblower. If your evidence is the crucial piece of evidence that's used in an enforcement action against a company, then you can win that, and you can stay anonymous. That $100+ million award went out, and no one even knows, definitely not the whistleblower's name, and not even which company they were working for. So the system works, the SEC system works better than you might think compared to some other government agencies. After we go to law enforcement, that would be step one. Step two would be typically taking disclosures to Congress or the California state legislature. Obviously there's definitely some members of Congress who are going to be supportive of your concerns. We can work with them to figure out, and if they share a disclosure with the media, it's much safer for you. So that's totally lawful, totally protected. We talked a little bit about NDAs, non-disclosure agreements, confidentiality agreements. People are more scared of those than they should be. I'm not saying that you can't be sued for violating them. You can, even a frivolous lawsuit against you can run up tens of thousands of dollars, even if you win, in legal fees. But those are typically less strong and enforceable than most workers are aware of. And we can help you reason through it, figure out what your risk tolerance is. And we have clients at all levels of risk tolerance to try to get around those things. So step two is often we take the disclosures that we gave to the SEC or the Department of Justice. We'll take that, or in the government context, an inspector general. We'll take that to Congress, and then we'll have a member of Congress share it with the media. That provides real protections for the whistleblower. If the journalist is getting it from Congress as opposed to the whistleblower themselves, it's much harder for a company to come after them. And then step three is the media. There's a lot of strategies around this. If you work for the government and it's classified information, we have a lot of experience with that stuff. It's pretty specialized. In the corporate context, we can help preserve your anonymity if you're trying to do that. We've had at least a dozen or two articles in the New York Times and every major outlet covering our cases over the last 3 or 4 years. So we can really assist with that. So those are, get a lawyer and then proceed with law enforcement disclosure, triggering legal protections, even if law enforcement is unlikely to act on your disclosure. 2, take it to Congress, have Congress share it with the media to provide protection. Obviously, we look at the NDAs. And then 3, work with journalists to tell the story. Just one example that we're working on literally this week. We have a client who's, I believe, is actually watching this right now, who has evidence that the global mobile phone networks are based, starting with third generation, but even up through the latest 5th generation mobile networks have serious security flaws in their design. The SS7 signaling process permits any telecom around the world to request data from Verizon or AT&T or whoever it is, including your geolocation, including the unencrypted contents of your SMS and even voice calls. You can be spoofed. They can make you look like you're somewhere where you aren't. And to give you a sense, 1 month last year, just on one U.S. network, there were over 2 million fraudulent requests coming from all over the world, from China, from Russia. They're obviously routed through intermediaries, so China, Unicom, or other telecoms, and surveillance for hire companies like NSO Group or Hacking Team use this and can buy access to see all of your unencrypted, any SIM card that you have that's connected to the network. So with this, we first went to the Securities and Exchange Commission, then we went to the Federal Communications Commission with the same disclosure, Federal Trade Commission, the Department of Justice, National Security Division. There's a counterintelligence angle to this too, because it's foreign intelligence agencies using this flaw in the network design that U.S. networks are not properly defending against the way they're supposed to. And now we've taken it to members of Congress, and just on Friday had a call with 2 journalists from the New York Times, but trying to get some coverage of this. So that's just one clear example of how this works. I'm going to wrap up quickly here, but the three take-home pieces of advice. Number 1, talk to a lawyer you trust before you do anything else. Do not talk to your boss. Do not talk to your friends. Definitely don't talk to a journalist either, because there's too many things that can go wrong. Create the attorney-client privilege as soon as possible and work from within that. Number 2, secure the evidence. Do not break the law while you're doing that. Do not hack into a network and commit a crime. Do not gain unauthorized access. Do not forward emails from a work account to a personal account or to your friend or anyone. If there's evidence in your email accounts, take your personal phone, take photographs, and use that as evidence of your screen. So obviously these companies all keep track of every email that moves. So number 1, talk to a lawyer and establish the attorney-client privilege. Number 2, secure the evidence lawfully. Number 3, in terms of security, do not use a work device for anything. Use your personal device. The best is to meet with people in person. Use hard copy paper print-offs. Burn those. Don't use email for anything. That's obviously hard to do, especially during a pandemic, especially if I'm in Washington, D.C. and you're in California. With the next sort of, level down in terms of security is over Secure Drop. If you go to our website, whistlebloweraid.org, there's instructions for how to access our Secure Drop site. That is the state-of-the-art, most secure thing you can do. It strips off all metadata, so even we cannot tell which IP address you're coming from or anything like that. Then the next level down from that would be a Signal message. The disadvantage of Signal is that your phone number comes to us when we receive a Signal message from you, the Signal app on your personal phone. If that's okay with you, you can send us a Signal message. Otherwise, use Secure Drop. All right, we're getting to the end of time here, so I will. The last two more quick points. We have already consulted with 2 different, besides the mobile network signaling issue, a name brand global, one of the tech company, one of the largest companies in the world, lying to, with a product that billions of people around the world use every day, lying to regulators and consumers about basic elements of that product. Help this person think through their options there. Number 2, a different social media company, again, name brand, household name, huge company, committing probably illegal election tampering in U.S. and foreign elections. Help people think through that. And then the last point that Meredith asked me to cover is what counts as misconduct. I would say we cast a broad net. We're very aggressive. We can be very creative. Anything that feels morally wrong, we will find a way to get you protected under the whistleblower laws. we'll be creative. All right, that's it. Thank you so much.
Thank you so much, John, for that. That was a lot of really valuable information in an incredibly condensed amount of time. So I'm glad that this panel and this YouTube that this will be on YouTube for people to review and to think about. We're now going to turn to questions from the audience, and the first one is, quote, "How important is it to be totally sure of a thing before you can whistleblow it? What if you heard a rumor at work?" And John, I will direct that one for you, but if anyone else has anything to say about that, we can follow up there.
I would be hesitant to proceed on a rumor. Again, if you can lawfully acquire evidence, do so. Do not do something that will get you fired or prosecuted to acquire the evidence. And I will say that we have a couple of matters now where we're spending 5 figures, I mean, $20,000 on one investigation. So we've hired a team of investigators to run stuff down. So if it's a credible rumor, we can put investigators on it, but I certainly wouldn't file anything we weren't totally sure of.
Great, that's really helpful. Doesn't look like we have any follow-ups. So the next question is, I signed a non-disclosure when I started a job and was asked to sign a different one when I left. I declined. How are they different? And maybe Ifeoma, you want to take this one, given your work on non-disclosure agreements, and then John, if you wanted to follow up on that.
Yeah, I can start. So non-disclosure is a term that can mean anything based on what is in the actual document. So unless you can see the 2 documents and compare them, it's hard to say definitively how the ones that you happen to sign are different. For whoever asked this, what I will say is mainly the issue is the non-disclosure and non-disparagement clauses that come in separation agreements. So when you start at a company, you're going to sign a ton of documents because, again, you have no leverage. You either sign them or you don't start your job and get paid. But when you start, a lot of the documentation you sign is around confidentiality, around IP, not sharing things that you learn that are trade secrets. There's next to nothing that's wrong with those types of documents. The documents that are a huge issue, especially when it comes to discrimination, harassment, and other workplace abuses, are the separation and severance agreements, where lawyers for the companies throw in all sorts of things, stating what you can and can't say, and using broad language that's broad enough that any lawyer worth their salt is going to tell you, in order to not be in breach of this contract, it's probably better if you don't say anything. And so that's where there's an issue. And NDA, it's important to remind folks again, can mean non-disparagement or non-disclosure, and you usually get both types of clauses in a separation agreement. The most important thing I can say about separation agreements, if you're not getting money, if you're not getting health insurance, don't sign that shit. They will tell you you have to sign it. You can't leave. What are they going to do to you? You hand over your devices and don't sign the agreement unless you're getting something out of it. And if you are, and you can afford it or you have the time, please find a lawyer to look through it and read through it just to have another set of eyes on it.
Yes, that was so valuable, Ifeoma. Thank you. John, anything you'd want to add to that rundown?
No, that was exactly right. I mean, there's essentially no way to give general legal advice. We have to read every document. We have to understand which jurisdiction it's from. We have to understand all of that. The only thing I would say is, so again, the messages come to us immediately before you do anything else. But I will say that people often take a pretty narrow legalistic view. And, is there a theoretical possibility you could be sued even with a frivolous lawsuit and run up legal bills? The answer is always yes. Anyone can sue you for anything. The question is, can we create a dynamic, a political dynamic, a PR dynamic for the company where it's disadvantageous to go after you? So even if you've broken an NDA, we can still, make it unlikely that they're going to come after you if we're able to strategize.
Great.
I will say, can I just add one thing though? I will say, as someone who went through this process, it's not just can you afford it and can you find a lawyer who can fight the frivolous lawsuit. It's also like, if this is not the right thing for you to do for your mental health, don't do it. Like, I honestly think that, yes, there are so many battles that need to be fought. I hope more people decide to speak up, but I will never fault a worker for not speaking up when you'd rather just move on and be at peace in your life. And the closer and faster you can get to that peace, the better for you.
Amen. That's good grounding. Thank you. I'll move to the next question then. How can whistleblowers across industries support each other and share their experience navigating the legal system, finding solidarity, being vigilant of retaliation, navigating NDAs, etc.? And I would love to actually toss this to both of you again. So Ifeoma, if you want to start, and then we'll follow up with John.
Oof, there's an unofficial network of those of us who have been through the experience, publicly at least, those who haven't, who have reached out, and we provide support to one another. And so I think just reaching out to people, like, I've never not responded to someone as long as they're not trolling. So people can feel free to reach out. One thing that I think people underestimate as far as support is speaking up publicly. I had former colleagues at Facebook who I had never talked to about what was going on at Pinterest, who, after I went public, voiced their support based on their experience working with me, and basically went out of their way to say, I know that people often question when Black women say that certain things have happened to them, but here I am as an ally standing up and saying, I believe this person and this is the work I did with them. That means so much in a moment when everything is being questioned and when you're actively being gaslit, as I still am by the company I used to work for. And so I think there are both ways to engage with someone directly to provide support, and then to do the solidarity calls that are so important.
Thank you. And John, anything you'd add to that?
Yeah, I mean, I agree. And I'll just speak from our organizational perspective. We see one of our missions as creating social capital connections between our clients and ourselves and the broader community and each other. And, I think we've been pretty successful doing so. One of our clients ended up joining our board of directors. A different client started, offered to make a bunch of videos for us. They're all kind of friends with each other now. They've all, because of the coverage of their cases, they've had other people reach out to them. And yeah, some people are going to hate you forever, but a lot of people are going to really be there for you. So don't, don't give up hope.
Yeah, the real ones know. I think, I want to also emphasize, I'll answer this from my own experience for just a moment, that having kind of your community in place is going to be really important while you're going through it, and having that mental health support, and reaching out to people who who may have been through it. I will testify, I also talk to a lot of people in this space who are sort of thinking through that floor dropping moment of, do I do this or do I not do this? And I know that I relied on some of, I really relied on that support when I was going through some of my struggles with Google. So yeah, I'll just add that, but thank you both for sharing there. And it looks like we have one last question before we wrap up, and that is, social media offers a more anonymous form of whistleblowing to affect smaller workplace issues. Do you feel such sites of resistance can be harnessed more effectively? So I'm interpreting that to mean kind of posting anonymously on Twitter or Medium, or sort of disclosing things through those mechanisms. And I'll toss that to John, and then Ifeoma, if you have any final thoughts.
Again, without knowing, I would say talk to a lawyer first. Maybe it's no big deal, but maybe there's some, maybe a journalist would want to write about it, and we could help set that up. Maybe it would subject you to risk. There's too many variables to give you a clear answer.
Yes, to there being a lot of variables. I will say that if it's something that you believe is really in the public interest and you think it's impacting other people, it is so important to be willing to go on the record, because I'm thinking, as an example, Business Insider did a story after Erica and I went public, and 12 people spoke to them anonymously in addition. The stories were important. It wouldn't have been published if 2 people didn't go on the record. So the more people are willing to go on the record, the larger a chance there is at actual accountability. Otherwise, companies often brush it off as just disgruntled ex-employee. There isn't even a name to put to it. So how can we believe any of these statements when I have no reason not to believe those accounts? But it's just really hard to build a credible story without a name.
Yeah. I would also emphasize sort of having journalists or media teed up, because social media is good insofar as it reaches people, but getting people to pick up that story is also a consideration in addition to all the rest. It looks like we have one more question that just came in, and it may be another one of the variety of kind of, need to examine each legal case on its own merits, but here we go. How are non-disclosure agreements valid across borders? I signed one in Europe and I'm now in a different jurisdiction. Do I have more freedoms? John, do you have a?
Yeah, legally we have to read it. We have to know which jurisdiction. Again, though, the legal analysis is only one piece, and even if you violate it, we can figure out how to make it unlikely you'll be sued. So
I'll add to that I signed my non-disclosure while living in California. I live in New Mexico now. It's still very valid. So, yeah. They follow you.
Yeah, New York, California to New York, same. So great. Well, it looks like we don't have any other questions. I'm not seeing any other in our question chat. So yeah, great. Confirmed we don't have any other questions. So I want to thank you all again sincerely. Thank you, Ifeoma. Thank you, Veena. Thank you, John. Thank you, Alejandro and Kyle. This has been a really great, and I think, I hope very valuable session, and that can live on as we, as a tech community, begin to think about this mode of accountability and begin or build on the work that Ifeoma, John, and others have done to create the infrastructures of protection for whistleblowers and create the infrastructures to whistleblow safely. Thank you all again, and we'll end it here. We'll be tweeting out all of the information that Ifeoma shared on the Silence No More Act, on the kind of issue around health insurance and how coercive health insurance tied to employers are for people making this choice, and some of the work that she is doing around resources for whistleblowers. We'll tweet out links to whistleblower aid, and we'll also tweet out information on some of those worker-led organizations like Gig Workers Collective and Rideshare Drivers United, the types of organizations that white-collar tech workers could collaborate with in thinking through what is the type of information missing and how to whistleblow in solidarity. So all of that will be coming probably tomorrow, because we don't want to keep everyone up late and people don't check Twitter in the evening. But I want to thank everyone. This will be online, and solidarity all. I appreciate your time and wisdom. Thank you, and good night. Good evening.
Thank you so much, Meredith.
Bye.
Thank you, everyone.
All.
Bye.